part 4 of our mega pack of 100 questions to get you through that real estate examination for 2025. Let's get you passed. Question number 76. What is the purpose of a quiet title suit in real estate? Letter A, to evict a tenant who has overstayed their lease. Letter B, to establish a clear title when ownership is in question. Letter C, to remove an encroachment from a neighboring property. Letter D, to transfer ownership of a property without a formal deed. And the answer? Letter B, to establish a clear title when ownership is in question. So part of the exam's vocab in the world of title and deeds is going to be a suit to quiet title. And so it's like a phrase that ends up showing up on examinations. Sometimes they'll throw it in the answer key and students might miss it. But a suit to quiet title is a legal action. And what it does is when there's a defect of some sort, it could be like, let's say, a chain of title issue, husband and wife, one of the spouses dies, and then they didn't correct the deed, which still says by entirety, even though the sole owner would be the surviving spouse through right of survivorship. We still have to mend that broken link to make sure that if it's Joe and Mary Smith, and now it's just Mary Smith, that Mary Smith has the right to sell the property, right? So we need to the property be put in her name in severalty. So to do that, this legal process is called a quiet title suit, or a suit to quiet the title. Question number 77. When a person dies without a will and no legal heirs can be identified, what happens to their property under state law? Letter A, the property reverts to the state, escheat. Letter B, the estate is distributed to heirs according to intestacy laws. Letter C, the estate is distributed according to the terms of the will, testate. Letter D, the property is held in probate indefinitely. And the answer? Letter A, the property reverts to the state called escheat. So this is the textbook definition of escheat. It is a government power. Escheat happens when somebody dies without a will. That means intestate. And then when somebody has no heirs. So it's intestate plus they don't have any heirs that we can identify. And when those two pieces happen, then escheat is the right of government to take the property, pay off any creditors, and basically absorb it back into society. Some states that you're taking this in, the escheat action might take place in the county, or the estate might be at the state level. So you just want to check that with your local states. Don't worry about it otherwise, because this is the definition across every state in the United States. Question number 78. Which government entity enforces the Fair Housing Act? Letter A, the Attorney General's Office. Letter B, HUD. Letter C, the FHA. Letter D, OSHA. And the answer? Letter B, HUD. HUD also stands for the Department of Housing and Urban Development. So here in this particular question, pretty simple. The key point to note is who is the enforcer. So what's interesting is for the majority of all of the other, consumer protection laws, it's not HUD. It's the Consumer Financial Protection Bureau. So we have one central enforcement division for all of these mortgage-related and real estate-related sort of consumer protection laws, except the Fair Housing Act, which the Department of Housing and Urban Development still has direct enforcement authority over it. And at the federal level, they have administrative law judges that listen to cases based on discrimination. So fair housing at the federal level is done with HUD, and then check your states to find out the name of the department that handles discrimination cases in your particular states, as that is probably going to show up on the state versions of your exams as well. Question number 79. Which of the following involves illegally pressuring homeowners to sell by falsely claiming that changes in the neighborhood's demographics will lower property values? Letter A, blockbusting. Letter B, redlining. Letter C, steering. Letter D, assumption. And the answer is letter A, blockbusting. So these are all going to be on examinations. The first three are legitimate prohibited practices: blockbusting, redlining, and steering. You want to definitely know the definitions of all three of these. Assumption is the thing, but it has nothing to do with discrimination. And the, we could, like, in terms of our business, it's an assumable mortgage or something like that. But again, it's the clear wrong answer, so we can skip that one. Which is the following, this in the definition here is illegally pressuring homeowners to sell by falsely claiming that the entry of a protected class would lower property values is called blockbusting. Now, sometimes they refer to blockbusting as panic selling on examinations. So they'll sometimes call it blockbusting, they'll sometimes call it panic selling. And the other thing to note is in the states that you're practicing in, do the states have any specific monetary penalties? Because this is a real estate agent's like discrimination, right? Blockbusting. It's trying to solicit listings by scaring people into considering that this financially is going to change. But the reality here is you want to check and see if in your state, are there any additional penalties, suspensions of licenses, etc., that will fall into play, as you'll probably be tested on blockbusting at some degree at the state level as well. Question number 80. In caveat emptor states, who is primarily responsible for conducting due diligence and inspecting the property? Letter A, the seller. Letter B, the buyer. Letter C, the real estate agents. Letter D, home inspectors. And the answer? Letter B, the buyer. So caveat emptor is Latin for let the buyer beware, or sort of beware the person that's buying something. And some states observe the real estate transaction in the caveat emptor sort of state, in that meaning, hey, buyer beware. You have to do your due diligence. Due diligence simply means homework. That's another vocab phrase that you want to know. And so the buyer needs to make sure that they hire inspectors and do all of their homework on the property to make sure that they're buying something. Obviously, no matter what, the seller must disclose known defects about the property that could adversely impact the health or safety of individuals. So you want to know that the seller still is liable for that. However, in caveat emptor states, they say the buyer really has to. Now, the opposite of this is in consumer protection friendly states. In those particular states, then the buyer still must do their due diligence. However, there are consumer protection laws that protect the buyer in the event that some kind of purposeful, intentional, or negligent misrepresentation takes place, which would have stopped the sale otherwise from going forward. Material facts of information or material defects. So again, you want to double check the state that you're in. You want to make sure you understand what the consumer protection laws in that state are, as this type of a question kind of couples with caveat emptor versus consumer protection laws. Question number 81. David is a real estate agent representing Amir, who is selling his home. Edward contacts David to ask about the property and schedules a showing. David provides Edward with accurate information but does not negotiate or advise him. In this situation, Amir is David's letter A, customer. Letter B, client. Letter C, principal. Letter D, both B and C. And the answer? Letter D, both B and C. So, first off, this is an agency-style question. This is a longer-winded question, which many times exam writers will throw on these types of examinations to kind of tire you out and confuse you. It's like the who's on first, what's on second kind of old bit. But so they want you to really be careful about that. If you have some sort of a dry erase marker, just kind of write it down. Make sure you understand what's happening and circle that. Now, the other piece to this question is the fact that a client is also called a principal. And so you need to know both of these pieces. Number one, you need to kind of identify who is being represented, but the number one wrong answer, believe it or not, is letter B. And sometimes students miss the word principal and they don't take it, right? So you want to make sure that client equals principal, and you also want to be able to calmly read through something like this and understand what the relationship is in an agency situation. Question number 82. If a broker produces a ready, willing, and able buyer for a property, but the day before closing, the seller changes their mind, the broker's commission, letter A, is forfeited. Letter B is due from the buyer. Letter C is due from the seller. Letter D must be renegotiated with all parties. And the answer is letter C is due from the seller. All right, so the answer here, letter C, is due from the seller, is the best possible answer here. And in this scenario, they're going to give you several of these, longer-winded interrogatory brokerage-style scenarios. If a broker produces a ready, willing, and able buyer for the property, now there doesn't say anything else. There's typically in the United States 3 prongs in order to earn a commission. Number one, you have to be hired by a party. So the seller hires a broker to sell their property. They might make a reference to a listing agreement or something like that. It could be an implied contract. It could be an express contract in writing. Now, there's a hiring, right? So we have to have a hiring test. Were you hired? Number one. Number two, did you produce a ready, willing, and able counterparty? To the seller in this example would be a buyer. Number three, can you establish procuring cause? So if you note in this particular question, there are some elementals missing. They didn't talk, overtly here or openly about the fact that they were hired, and they only simply said that they produce a ready, willing, and able buyer. Now, this just I want to make sure students understand stuff. When a question is crafted, maybe there's a possibility that every element or dimension isn't completely covered. And in this particular question, that wasn't the case. So if I'm reading it to interpret this, the best possible answer is still going to be C, even though they don't talk about a hiring, even though they don't talk about procuring cause. By the way, procuring cause is the third prong. Procuring cause means that you started a chain of events that ultimately leads to the deal closing. You were the catalyst to the reaction of the deal being closed. So you want to also be able to establish that. Now, there is a fourth prong in many states. That prong says that the deal also must close. So if you're in a state that requires that the real estate transaction also close in order to earn a commission, you want to check that part out in the states that you are practicing in for your state examinations. But on the general exam, those are the 3 tests. Be hired, produce a ready, willing, and able counterparty, and establish that you're the procuring cause. Once you've hit all those markers, then you're entitled to a commission, even if the seller were to back out for no good reason, right? So the answer here is C. It's the best possible answer, even though in the question there was a little bit of information that wasn't included. That's okay. You still want to pick the best possible answers that are available to you. Question number 83. Homeowner Megan wants to sell her home. She makes an agreement with brokers Elena, Paula, and Frank. Whichever broker finds the buyer will get the commission. What kind of agreement is this? Letter A, net listing. Letter B, exclusive agency. Letter C, exclusive right to sell. Letter D, open listing. And the answer is letter D, open listing. So there are several types of listing agreements or arrangements that we want to be familiar with. The open listing is when we give it to more than one brokerage firm exclusively. So if we give it to several, even if we give it to 2, we are creating an open listing contract. First come, first served. Whoever finds the counterparty to this transaction, whether it be a rental or whether it be a sale, is going to earn the commission. In many urban cities, big cities that do a lot of rentals, this happens to be the norm. You'll see a landlord give their listing out to multiple brokerage firms, first come, first served. And that's what an open listing is. An exclusive agency and exclusive right to sell are when we have exclusive written contracts hiring a specific brokerage, and you want to know the definitions of these, and you do want to know the definition of a net listing, as it will also show up on an exam. These are all legitimate things. Good question for an open listing. Question number 84. What is an agent's role when addressing environmental hazards in real estate transactions? Letter A, direct their client to consult with an expert on any potential hazards. Letter B, be able to identify potential hazards. Letter C, ensure all required disclosures are made to potential buyers or tenants. Letter D, all of the above. And the answer? Letter D, all of the above. So in the world of agency, when it comes to environmental hazards, all of these are essential. Directing their clients to consult with an expert, absolutely. We are not environmental experts. We must encourage them to seek out professional help when it is appropriate. Letter B, to be able to identify potential hazards. In that regard, it's more of a visual inspection. Do I understand that there could be something? Hey, you might want to get that checked out. Hey, you might want to consider getting this checked out. Hey, you might want to consider this. So we're encouraging inspection. So another way to discuss this is to be able to identify potential hazards is to encourage inspections. And the letter C is ensure all required disclosures are made to potential buyers or tenants. We're talking about things like lead disclosures and radon and things of that nature. So they could be physical paper disclosures that the state requires, or even on the federal level like lead disclosures, or it could be oral disclosure of material facts that we may know or we may not know. We want to encourage inspections for those. And so any disclosures, any potential hazards, or directing them to seek out professional help is all important for the agent to do when they're dealing with environmental hazards in real estate transactions. Question number 85. What does a promissory note represent in a real estate transaction? Letter A, assets. Letter B, debt. Letter C, hypothecation. Letter D, amortization. And the answer is letter B, debt. So a promissory note is coupled with the document called a mortgage, and together this makes up a mortgage loan. So a promissory note is the second piece, the mortgage document is the first piece, and the promissory note is an agreement between the lender and the consumer to pay back a debt. So it's really about a debt. I mean, you could look at it another way. You could say that it's an asset for the lender, right? But the answer here is debt. And hypothecation is pledging of property in exchange in the future for future possible default. That's hypothecation. Amortization is another phrase. So you really want to know what the definitions of hypothecation and amortization are. Those are absolutely things that could show up like this in this kind of way in the answer key. But you also want to know a promissory note is a representation of debt. Question number 86. What are the defining characteristics of a package mortgage and a chattel mortgage? Letter A, a chattel mortgage includes only real property, while a package mortgage includes only personal property. Letter B, a chattel mortgage includes only personal property, while a package mortgage includes only real property. Letter C, a package mortgage includes real and personal property, while a chattel mortgage only includes personal property. Letter D, both a package mortgage and a chattel mortgage can include both real property and personal property. And the answer is letter C, a package mortgage includes real and personal property, while a chattel mortgage only includes personal property. So these are two legitimate types of mortgage packages, mortgage loans. Package mortgages will include security on personal property items as well as real property items. So that's a legitimate thing. And then chattel, another word for chattel is personal property. So a chattel mortgage is only financing for personal property effects. And so letter C is the answer to this question. You definitely want to know the different types of mortgages, including things like package and chattel, cross-collateralization, blanket mortgages, full amortization, partial amortization. These are all phrases that are very common on these types of exams, so make sure you study them. Question number 87. Federal fair housing laws protect all of the following categories except letter A, color. Letter B, pregnant women. Letter C, marital status. Letter D, familial status. And the answer is letter C, marital status. So familial status is the right to have small children living in the property or a pregnant woman. So pregnant women and familial status are this protected class. So they're covered under the familial status protections. Color is obviously one of the original protected classes. So we have 7 protected classes at the federal level. You want to remember race, color, religion, national origin, sex, familial status, and disability. With familial status, there is a subcategory that includes a woman that is pregnant. So we have that also. And then so marital status. Now, marital status, a lot of people pick under federal fair housing laws, and it's not covered under federal fair housing. It is covered under the Equal Credit Opportunity Act, however. So that is one of the protected classes that the Equal Credit Opportunity Act has compared to the Fair Housing Act. So you want to know the comparison between those two laws, and many times you'll see them. So you want to know what are the protected classes, what are the similar protected classes between ECOA and fair housing, and where are they different? And knowing those will help you on this exam because they are going to split hairs about it on the federal level. Question number 88. A proration of any prepaid utility charges is most often reflected on a settlement statement in which of the following ways? Letter A, a debit to the buyer and a credit to the seller. Letter B, as a debit to the seller and a credit to the buyer. Letter C, as a debit to the seller only. Letter D, as a credit to the seller only. And the answer? Letter A, as a debit to the buyer and a credit to the seller. So when we're dealing with prorations of prepaid utility charges, then you want to remember that no matter what, first and foremost, if there's a credit to one party, then there's a debit to the other party. These prorations have to reconcile. So if you're charging one person for it or one person's paying for it, but the other person's getting a credit for it, that's how that works. So remember, prorations flat out, it's never going to be just a debit only to one side or a credit only to one side. When it's coming down to utility charges, that's what they're specifically talking about here. So you want to understand how these typically will be reflected, and you'll find all of this information inside of your books under closings and settlements and prorations. Question number 89. Which of the following tasks is an unlicensed real estate assistant permitted to perform? Letter A, host an open house. Letter B, generate and distribute commission checks. Letter C, submit an offer for a client if the broker is out of town. Letter D, attend property showings on behalf of their employing broker. And the answer is letter B, to generate and distribute commission checks. So basically what they're boiling this down to, and by the way, unlicensed assistants are definitely going to be covered on exams. Namely, you'll probably see them more often on brokers' exams than salespersons, but they want a salesperson to also know that an unlicensed individual at a real estate firm cannot make representations, or the consumer can't be confused into thinking that they're licensed, at all. So they cannot do anything that a licensed agent can do. Hosting an open house, absolutely no way. Submit an offer, no way. Attend property showings on behalf of their broker, no way. Unfortunately, a lot of people in practice break this rule, and they have their assistants do all of this stuff, and there's a lot of assistants that are doing licensed work, and they're unlicensed. However, you want to know for the exam, it's got to be something that's more clerical or administrative, and that's the one to pick. So in this example, it's generate and distribute commission checks. That is something clerical and administrative, no big deal. Question number 90. Frank owns 3 acres of land and sells 1 acre to a neighbor, but he reserves an appurtenant easement over the neighbor's land to access a pond at the back of the property. In this scenario, Frank has letter A, a servient tenement. Letter B, a dominant tenement. Letter C, land subject to an easement in gross. Letter D, none of the above. And the answer is letter B, a dominant tenement. So you want to know easements for real estate examinations. They are definitely going to be on there. And a pertinent easement has 2 types of tenements. One is a dominant tenement. The dominant tenement gets the use. The servient tenement allows the use. So in this case, Frank owned 3 acres and sells one of those acres to a neighbor. The neighbor that gets this, they're getting the acreage with the appurtenant easement attached to it. It runs with the land, and therefore they have to allow Frank onto the property to access the pond. Therefore, Frank's estate is dominant. They get the use. They get the right to access to the pond, and the other owner now is the servient tenement to this transaction, this easement that has been created. So you want to know who's dominant, who is servient. You want to know about different types of easements, appurtenant easements, easement by necessity, easements in gross, and easements by prescription. Question number 91. In a limited partnership, roles and responsibilities are divided between general and limited partners. Which of the following best describes the management structure of a limited partnership? Letter A. The general partner manages the business and makes operational decisions. Letter B. The limited partner manages the business and are involved in daily operations. Letter C. All partners share equal responsibility for running the business and making decisions. Letter D. One partner is elected by majority vote to manage the business and make decisions. And the answer is letter A. The general partners manage the business and make operational decisions. And in limited partnerships, the limited partners are passive, really make no management decisions, and the general partners are making that. So you want to know that limited partnerships have that, general partners and limited partners, and then we have different things like LLCs, and we have different things like corporations, and sometimes you're going to see these different legal entities be represented on examinations. You definitely want to know a little bit here. You're not going to see a tremendous amount of questions when it comes down to this stuff, but you definitely want to have a little bit of an awareness when it comes down to it. Question number 92. A house sold for $480,000 and the buyer obtained an FHA insured mortgage loan for $420,000. If the lender charged 2 discount points, the buyer would pay letter A, $8,400. Letter B, $9,600. Letter C, $1,200. Letter D, $4,200. And the answer is letter A, $8,400. All right, so this isn't super complicated, but the things to remember, anything points. 1 point equals 1% of the loan amount, okay? The fact that it's an FHA insured mortgage loan, that's really non-essential for this particular question. They just threw it in there. They threw in 2 numbers, which is classic. They're going to do stuff like that to trip you up. They're going to give you a number based off of 480. They're going to give you a number based off of 420. You just need to remember that all discount points, all loan origination fees are based off of the loan amount, not off of the purchase price. So we're going to use the lower of the 2 numbers in this particular instance, $420,000. 1 point equals $4,200. The lender charged 2 discount points. A discount point is a way to increase the lender's yield, by the way. You went into the definition of a discount point. And so each one is $4,200. That's 1 point of $420,000, 1%. And then they paid 2, so it's times 2, which is $8,400. Question number 93. What taxes are imposed on property owners to fund specific improvements such as sidewalks or sewers? Letter A, standard property taxes. Letter B, ad valorem taxes. Letter C, excise taxes. Letter D, special assessments. And the answer? Letter D, special assessments. So we want to know what a few of these items are: ad valorem taxes for sure, and special assessments. And these are the 2 standouts. Standard property taxes, standard property taxes are ad valorem taxes. So that's another kind of really watered down way of describing them, which they're not going to do. They're going to call them ad valorem taxes. So there are 2 types of taxes: ad valorem and special assessment. Question number 94. What is the term for the illegal practice of guiding prospective buyers or renters towards or away from certain neighborhoods based on their race, religion, or other protected characteristics? Letter A, blockbusting. Letter B, redlining. Letter C, steering. Letter D, market allocation. And the answer is letter C, steering. So blockbusting, redlining, and steering are always going to be on real estate examinations, both on the national exam and the state sections of your exams. So you want to know these phrases. Market allocation has something to do with Sherman antitrust. So it's a legitimate phrase, but it has nothing to do with discrimination. So you can actually, by process of elimination, if you're kind of reverse engineering these questions, you can eliminate letter D and you can say, well, which one is it? And then you just need to know the definitions. Remember, blockbusting is also known as panic selling. Redlining is not making a loan or issuing insurance policies in an area for reasons other than economic qualifications. And steering is guiding prospective buyers or renters towards or away from certain neighborhoods based on protected class or characteristics. Question number 95. A homeowner sells their property and decides to take the chandelier from the dining room when they move. Before closing, the buyer notices the missing chandelier and demands its return. Who is likely correct in this dispute? Letter A, the buyer, because the chandelier is a fixture and considered part of the real property. Letter B, the seller, because the chandelier is personal property. Letter C, the buyer, because all items in the home automatically convey unless removed prior to listing. Letter D, the seller, because lighting fixtures are never considered real property. And the answer is letter A, the buyer, because the chandelier is a fixture and considered part of the real property. Now, this is a tricky question, and I'm going to say that this is probably the best answer with the information being provided. All right, so I'm a little on the fence, but however, I will say that letter A is probably where I would have gone towards as well. And so really, as we learn in real estate courses, that there's an intention of the parties. There's also this concept of parole evidence rule. And there's also this items of, what will be added to the contract and what won't be added to the contract, or specifically included or excluded. And so there's a lot of other variables that happen. So for I always tell students, because if people push back on questions, which happens occasionally, they're like, well, you didn't explain this right, or you didn't do this. Well, I'm going to say, follow the path of the question. Many times, if I'm not writing this particular question, I'm many times just being presented with this question, for my team, and it's like, okay, it's done by design, because on the exams there's going to be weird grammar and weird scenarios. It's not picture perfect. Trust me, when you go out there and take these actual tests, you're going to be like, man, what the heck was this? This question doesn't even make sense, or is so half baked. It doesn't make any sense. And you're going to see that on the real examination. It's not like you have these experts that are writing things so perfectly grammatically correct that everything's going to line up. So we do this purposefully. And in this example, A would have been the best possible answer, because the chandelier is considered a fixture and considered part of the real property. At the end of the day, I've seen cases in the field where a seller takes an expensive chandelier because they determined it to be a personal property, and they replaced it with a light fixture, which they could have added in this question, which would have been a little bit more clarity or confusion. I'm not sure. But be careful. Focus on the question and the intention of the parties, and that typically will guide you. Question number 96. Maria is a real estate agent representing Jacob, a buyer. During a showing, Maria reveals confidential details about Jacob's finances to the seller's agent to help secure an offer. Which fiduciary duty has Maria violated? Letter A, loyalty. Letter B, disclosure. Letter C, obedience. Letter D, accounting. And the answer is letter A, loyalty. So in this particular instance, her duty to serve Jacob, her buyer client, would have been a violation of her loyalty. Every action and inaction that she takes must directly financially benefit her client or principal, as fiduciary duties and obligations sort of dictate. Now, another possible scenario could be her duty to confidentiality, and that's not listed here. So in this particular case, disclosure, obedience, and accounting were not the items that I would have selected. I would have chose A as well, loyalty, and that one makes sense in this particular scenario. Question number 97. Which of the following best describes syndication in real estate? Letter A, a company that owns, operates, or finances income-producing real estate, often traded like a stock. Letter B, a group investment structure where multiple investors pool funds to purchase and manage real estate. Letter C, a method of dividing land into smaller parcels for sale or development. Letter D, a partnership formed exclusively between two real estate agents to co-list a property. And the answer is letter B, a group investment structure where multiple investors pool funds to purchase and manage real estate. So the textbook definition, the basic definition, one of many, of what a syndication is that with this section, you don't need to know a tremendous amount. You need to understand what is fundamentally a REIT, a real estate investment trust. What is the definition of a syndication? And these two things will typically help you. You'll see this in the investment sections of your real estate textbooks. They're not going to play it up too big, but you're going to see these, and hopefully you get these. These are going to be relatively easy. I hope you get them, and I hope you nail this one. Question number 98. The primary purpose of the Truth in Lending Act is to, letter A, control interest rates. Letter B, protect consumers. Letter C, protect consumers and financial institutions. Letter D, protect financial institutions. And the answer? Letter B, the Truth in Lending Act is a consumer protection law. So is the Real Estate Settlement Procedures Act. So is the Equal Credit Opportunity Act. So is the Fair Housing Act. At their essence, they are made and created to help consumers. So these are consumer protection laws, and that is pretty clear cut in terms of what is the purpose of the Truth in Lending Act. Question number 99. Which of the following is not a required element of a valid real estate contract? Letter A, mutual agreement. Letter B, legal purpose. Letter C, consideration. Letter D, notarization. And the answer? Letter D, notarization. So to notarize a valid contract is not required. There are essential elements of a valid contract. Mutual agreement, which means there's an offer and an acceptance. Legal purpose, a contract cannot be for an illegal purpose. It is therefore void. We've talked about this. Consideration is definitely an element. Legal capacity. The parties need to be of sound mind and body entering into the contract. And so we need to make sure we know what the elements are for a valid contract, and notarization simply is not one of those. Question number 100. A buyer purchases a home and later discovers an undisclosed lien on the property. What protection could the buyer rely on to cover financial losses related to this defect? Letter A, the purchase agreement. Letter B, a special warranty deed. Letter C, a title insurance policy. Letter D, the appraisal report. And the answer is letter C, a title insurance policy. This is what a title insurance policy does. One of the things is it covers financial losses of the buyer and the lender in the event of certain things like undiscovered liens, title defects, anything that deals with title issues. And so an undisclosed lien in this particular question is a title issue, and there could result a financial loss, and therefore title insurance would be the correct answer. You want to know a little bit about title insurance, what it covers, what it protects, when the policy premiums are paid one time at closing, and you want to know the difference between an owner's policy and a lender's policy. You also want to know what are some of the items that they cover and what is an extended versus standard coverage policy, and you should be good to go. Title insurance is definitely something that you want to know for this exam. All right, we have gone through 100 questions, and man, I am telling you, these questions are going to help you get through this examination for 2025. My name is D. Kumar. Thank you for checking out the 4 episodes, and thank you for all of the amazing feedback, and thanks for subscribing to our channel and supporting us and what we do. It is our intention to support you, each and every one of you, to help you get through real estate exam questions, mortgage exams, and be able to get through, get those licenses and move on to become the greatness that you have to become in order to serve you and yours. So it is with utmost pleasure and respect I want to thank you again for tuning into this. Be tuned to many more to come. And if you have questions, if you have comments, if you have interests to learn about, leave them in the comments. Please subscribe if you haven't. If there's anything we can do to serve you more, please reach out to us in the comments. Thank you once again for taking the time to spend that with me. I hope it yields you success. Good luck with your studies. Good luck on your exams.